I'm Ben Meiselas from the MeidasTouch Network. The impact of the monumental Supreme Court case Allen versus Milligan, which upheld Section 2 of the Voting Rights Act of 1965 in connection with a challenge by the state of Alabama to try to put in place its racist gerrymandered maps. When a federal district court struck that map down, the ramifications of the Supreme Court holding in that case is now being felt. A new ruling was just issued in the case of Ardoin versus Robinson. This is a case we've been talking about here at the MeidasTouch Network in Louisiana, where the holding ultimately of Ardoin v. Robinson was going to be tied directly to the challenge being made by the state of Alabama, a challenge, fortunately for democracy, that failed in Allen versus Milligan. And so in this ruling that was just issued today in Ardoin versus Robinson, the court held that the Louisiana map that was used in the 2022 midterms was indeed an unlawful map. It was permitted to be used given the fact that the ruling by a district court judge blocking that map was stayed by the United States Supreme Court pending its ruling on its Section 2 cases in Allen versus Milligan. So as a result, it certainly changed the results of the election in 2022. But here's the ruling that just issued from the United States Supreme Court. Monday, June 26th, 2023, summary dispositions. Here's the case: Ardoin, Louisiana Secretary of State et al. Versus Robinson Press et al. The writ of certiorari before judgment is dismissed as improvidently granted. The stay heretofore entered by the court on June 28, 2022 is vacated. This will allow the matter to proceed before the Court of Appeals for the Fifth Circuit for review in the ordinary course and in advance of the 2024 congressional elections in Louisiana. See this court's Rule 11. So essentially all that means is that the district court's ruling, which blocked the racist map, the racist gerrymandered map, which was permitted to be utilized in the midterms because the district court's order was stayed. The district court's order is now in effect. It is now going through the normal court processes and procedures before the Fifth Circuit Court of Appeals. But the Fifth Circuit Court of Appeals did not stay or stop the district court's order. So in effect, what this basically means is that Louisiana is going to have to redraw their maps based on this ruling, which would include at least one other congressional district that would be representative of the black population in Louisiana, because currently, while the black population in Louisiana is over 30 or 33%, there's only representation in one congressional district, and that's what federal judge Shelley Dick struck down in her order in 2022. I think it was in June, but then the Supreme Court ultimately stepped in and stayed her order pending a full briefing, pending oral argument. And ultimately what happened here is, because this ruling was dispositive based on the outcome of Allen versus Milligan, when the court upheld Section 2 of the Voting Rights Act in Allen versus Milligan, that then became precedent for this case. Section 2 of the Voting Rights Act of 1965 is upheld, and therefore what the district court judge ruled in striking down the racist map was the correct and appropriate ruling. I mean, just to remind you of the case of Allen versus Milligan, just so you know where these cases get their names from, Allen is the Secretary of State of Alabama, last name. Ardoin is the last name of the Secretary of State of Louisiana. They're sued in their official capacity, and that's just why these cases are named the way they are. These cases are brought by either legislators or civil rights groups who are impacted by the racist gerrymandering. And what had happened in terms of Voting Rights Act litigation is that before 2013, there would be what was called a pre-clearance requirement in Section 4 and Section 5 of the Voting Rights Act of 1965. So when a state would engage in a gerrymandering process, it would have to submit the map to the Department of Justice or this 3-judge district court panel to approve or not approve the map in the first instance about whether it complied with the Voting Rights Act. The pre-clearance requirement, and frankly, the Voting Rights Act of 1965 has been attacked over and over and over again by Republicans. And so in 2013, there was a decision called the Shelby decision in the United States Supreme Court. The United States Supreme Court ruled that the pre-clearance formula was unconstitutional, which is in Section 4, and then that negated the Section 5 pre-clearance. So for the first time, since the new census took place in 2020 with the 2022 midterms, it's been the first time there hasn't been this pre-clearance requirement. So what's happened is a lot of states like Alabama and Louisiana, a number of states controlled by Republican legislatures, have put forward these racist gerrymandered maps because they wouldn't have to get pre-clearance approval. So they would wait until the very last minute now, until when the map had to be presented in order to allow an election to take place. And now the burden shifted to civil rights groups to have to initiate litigation, try to demand a preliminary injunction to try to block the map. And where they succeeded in blocking the maps, like they succeeded in the civil rights groups that filed lawsuits, succeeded in the district court in Alabama before the midterms, succeeded in Louisiana before the midterms. But then what would happen is the Secretary of States of these Republican-led states, they would then appeal that to the United States Supreme Court, and they would cite this principle called the Parcell principle, being that the maps that are created by the state legislatures should not be disrupted if it is so close to an election. So this Parcell principle precedent, very warped precedent that's been created by the Supreme Court, was then utilized by the Supreme Court under what's been termed its shadow docket to basically make these rulings that would overrule or stay or stop these district court decisions temporarily and basically say, look, under the Parcell principle, we are blocking what you're doing in the district court. The maps that were submitted by the state legislatures are permitted to stay in effect pending the results of the election. And then after the election, we'll have full hearing and full oral argument, but we don't want to disrupt the state legislature's maps with, even if they're racist gerrymandered maps, before the election. So that's why now in 2023, the Supreme Court in its 2022 term heard oral argument and then made rulings, and that is what we are seeing now. So the big takeaway of this ruling today, though, which is related to the Allen versus Milligan Supreme Court ruling back from June 8th of 2023, is that Louisiana is going to have another district that's going to be voting Democratic. That's typically the way the voting blocks would normally work. And let me just read for you, just give you some background here of what went down in Louisiana. This is from Democracy Docket. It talks about this case, Ardoin v. Robinson. It talks about that it was a lawsuit filed on behalf of voters and civil rights groups challenging Louisiana's congressional map. The complaint points out that even though black residents make up 1/3 of Louisiana's population, they can only elect their candidate of choice in 1 out of the 6 congressional districts. The plaintiffs argue that by failing to include a second minority opportunity district, this new congressional map dilutes the voting strength of black residents in violation of Section 2 of the Voting Rights Act. Because of this, the plaintiff asks the court to block the map and order the creation of a new map that includes a secondary minority opportunity district in compliance with the Voting Rights Act. And on June 6, 2022, a preliminary injunction was granted by District Court Judge Shelley Dick blocking the congressional map for the 2022 election cycle. However, the United States Supreme Court then on June 28th, 2022, stayed the district court order, allowed the racist maps to be in place during the midterms. But now in today's order by the United States Supreme Court, they're basically saying, yeah, oops, we shouldn't have done that. Sorry. At the end of the day, based on our ruling now in Allen versus Milligan, follow our precedent there. Too bad, so sad, even if that altered the results of the election. But this bodes well for 2024, of course. And now what we're seeing as a result of the decision in Allen versus Milligan is there's been a huge flurry of Section 2 litigation because a lot of these district courts were now saying, well, we now have to wait until what the Supreme Court does in Allen versus Milligan before we make our any rulings on Section 2. And just so you know what Section 2 says, it says no voting qualifications or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision in a manner which results in denial or abridgment of the right of any citizens of the United States to vote on account of race or color or in contravention of the guarantees set forth in Section 1973B, which essentially adopts the language of the 15th Amendment. But it's been a major priority of the modern-day Republican Party, going back a long way, to attack the Voting Rights Act of 1965. And their essential argument, I'll break it down in very simplistic terms, is they say the Voting Rights Act of 1965 is ultimately racist to white people by focusing on racial criteria to determine whether there should be congressional seats. The whole point of the Voting Rights Act of 1965 is that the systemic racist histories of places was a law passed by Congress. And this was the way to deal with systemic racism and to address situations where states like Alabama or Louisiana may block the ability of black representation in the states through a pattern and practice of systemic discrimination. So when you see, okay, in Alabama and Louisiana, that the black population is 35%, 36%, whatever it is, and they're only getting one congressional seat, you could see, well, there's clearly insidious things happening behind the scenes here, and that needs to be addressed. And what the Republican states argued why Section 2 should be eliminated is they said we should make it race neutral. But at the end of the day, their concept of race neutral ignores the fact that they use other criteria to then be racist, to block the voting rights of a minority. So it's actually not a race neutral thing that they're really advocating for. They just use that terminology. So a lot of people were waiting to see what the results of Allen versus Milligan was going to be. It was a 5-4 decision. Justice John Roberts wrote for the majority. It's now having this ripple effect. We're going to see a lot of other districts that should have been Democratic in the first place, because district court judges found the maps by the Republican legislatures to be racist, gerrymandered maps. But we're going to start seeing now remedial measures and remedial orders, and we're starting to see that here. So another big order by the United States Supreme Court today. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 1.5 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch. Wherever you get audio podcasts, subscribe to the MeidasTouch podcast. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.